And my Lord, we earlier informed this court that there are amendments that will be done to this indictment. And therefore, do not wish to specifically respond to a matter that relates to amendments which we have already informed this honorable court and the defense that we intend to have amendments to this.
And in view of the fact that justice should not only be seen to be done, but be seen to be done, that is of great concern and is something that is likely to cause less faith in administration of justice, as the question will linger whether the court, and in particular this court, is acting on its own or there are other strings being pulled. That having been said,
I am saying avoid those situations here. You see it on yellow? Start situating here.
it is my duty to voice the concerns. It's been in the media.
I am the one handling this case. I am not handling the media. So proceed.
So maybe that you may wish to issue a caveat to politicians in government, including the highest office, to stop commenting on this
I have
case.
no problem with that if you would make that.
Yes, I am urging the court, therefore, to put a stop to pronouncements that are likely to prejudice the hearing of this case. That was the whole object of bringing that in, because it's of great concern. Otherwise, having noted our objections,
My Lord, in addition to, first of all, I agree with the submissions made by the senior counsel, but I would like to add that, my Lord, that it will be regular. My Lord, to proceed with retaking when the instruction is given to us, my Lord, they were restricted to receive the ruling. The amount, my Lord, you are visiting. We are compelled to represent their chosen persons in a matter where we are yet to receive instructions. Bearing in mind, my Lord, that is mandatory under the Constitution for their chosen persons to be effectively represented. And my Lord, effective representation presupposes, my Lord, interaction with their chosen persons, have an interaction between lawyers and the chosen persons. My Lord, the final one is about the regularity, the propriety of the proceedings, the propriety as well. Because, my Lord, there is a pending bail application by order. That is A3. When we last appeared here, my Lord, when we last appeared here, the indication was that it was adjunct to defamation. And good enough, counsel for lie is here. And my lord, procedurally it would be improper to proceed with a substantive session case in disregard or total disregard of the pending miscellaneous application. That the registrar must give adequate notice, must serve it. Of course, the same will be served on the accused persons and the DPP at least 14 days prior to the proceedings. And this all was not done, my lord. All this was not done. So it will be fatal, my lord, for this court to proceed to administer a plea to death. It will be fatal. And good enough, the prosecution seemed to be conceding to this. And as submitted, that will occasion the miscarriage of justice. So we pray that you be pleased to defer the matter.
At the time when the accused persons were being admitted to stand trial before this honorable court, they were given copies of the indictment. My lord, the prosecution does not sign on behalf of the registrar. My lord, this is power reserved for the registrar. And my lord, it is not for the prosecution to serve a signed copy to the defense, because this is a power restricted to the court. So, my lord, I think this is misconceived. My lord, the matter has been raised about the particulars of A3. And my lord, particularly, the accused person has been in possession of his indictment since he was committed, and these matters were not raised. It is just being raised before this court, before the plea is taken. And my lord, it is prudent for the prosecution to have this amended as to his name and age. So, my lord, and my lord, it becomes further difficult with the presence of all these many applications after applications which have been before this court to have these amendments done before the matter is actually set for proceeding. And it is also not true that today, the 29th of December 2025, it is also not true, like my learned friend said, that he did not expect the prosecution to amend it today. We are not saying we are amending it today. We are proposing that we will have this anomaly in the process of this matter proceeding. But this cannot be done when there are numerous applications after applications.